Hey, Bob. So, welcome and thank you so much for taking the time to speak to me today. So, if you could do me a favor and just introduce yourself.
Sarah, it's my pleasure. I'm Bob Boland. I'm currently a professor at Seton Hall University Law School, where I help anchor the sports law curriculum. I think fairly simply to say I'm a sports lawyer by trade and by training, and now for a long period of time. I'm also a board member at Culture and Sports. So this is a unique pairing of where my interests professionally and personally lie, because talking about interesting topics through sport, bringing greater understanding is a real big goal of mine. Also, I've served in a number of capacities. I've been an educator, leading sports management programs at NYU and Ohio University, before joining Penn State in the weirdest of roles, but as athletic integrity officer, where I did touch to some degree some of the issues of fundamental fairness and participation that are being brought up now in the cases we're going to talk about. Um, I'm a believer in only one thing in sport, that participation is a good thing, that competition is generally a good thing. And it leads to better and broader understanding. And we're seeing in these cases, um, remarkably, a case where understanding isn't being brought. And I'll share this anecdote, not necessarily a perfect one, but I worked at Penn State as the athletic integrity officer, and I would receive calls and ultimately began to receive death threats at Penn State for Leah Thomas, who was going to the University of Pennsylvania. So I got to be on a first name basis with the police officers at the University of Pennsylvania. I got to talk to their Title IX coordinators, and it was remarkable how I could attribute that to tweets and other statements by political figures on the right, to how the threats and calls came in, often with the sorry, wrong school conversation. So I do understand the pressure and how hot an issue this is.
Yeah, thank you. So, I want to start with something that I know that you have particular knowledge and expertise about, which is, what are the legal and functional differences between athletes at the high school level and athletes at the collegiate level?
Well, that's a really great question, and there are some narrower brush strokes to take on this, because college sports sort of exists at three different levels in the NCAA, and then two different levels in the NAIA. But if we were to think broadly about it, in almost every legal sense, college athletics is viewed as a privilege, which creates some conflict legally for people who are using it as a career advancement step. And it puts some of the regulatory bodies in college athletics, the NCAA most notably, in something of a legal weird spot, because you don't have a right of participation necessarily in college sports. Almost every school has, even public ones, have adhered pretty strongly to the fact that it's a privilege subject to revocation. The NCAA operates on that, and almost all of college sports has been viewed through the lens of private association law. Um, High school sports are a little bit more of a hybrid, because they are school or sponsored, school created, that you have certain greater rights of participation by virtue of your status as a public school student, and the idea that that law applies there. We've seen a lot of conflict in recent years between state associations, something we're going to talk about a little bit more, and that right of participation, because they attempt to define those rights and determine eligibility and try to create the levelest of playing fields in the most benign of senses, but oftentimes they go a little too far and can be power hungry, abusive, and try to operate under the theory that they're private entities when they really are sort of quasi public. But if we're thinking about just sort of the more broad ethos, the idea that high school sports is a participatory process, and not everyone in it is competing to advance broader aims, whether that's aims toward professionalism, whether that's aims to a college scholarship. It's broader than that. It is a broader cross section of people. In college sports, particularly where scholarships are involved, and there is a scholarship incentive, we're beginning to start to think about athletes as potential employees. Not, we haven't gotten there yet illegally, but that's an issue that we're there. And if you think about it, really from the broadest part of it, college costs anywhere between $30,000 and $100,000 a year, and sometimes that athletic scholarship is the only thing keeping that certain student in school. So they do have a really important value there, even if they're not going to be professional athletes and earn hundreds of thousands of dollars. And that really does create some conflict at every level. In my time as the athletic integrity officer at Penn State, the athlete who was going to be cut from a team or possibly lose their scholarship was sometimes the most dire of circumstances that would come to me. And in some cases, it was being done outside the rules, and I would have to stop and intervene in the process. So we see athletics really existing in a variety of levels, from recreational participation to collegiate participation as an aim to pro sports. They're a huge business nationally. I trace college sports just sort of top of my head. College sports would be slightly smaller than the NFL in overall spend and earn, as the largest or most valuable U.S. Sports entity. Now that's thousand institutions, but it's about $19 billion annually that we're talking about is spent or is earned in the college space. So it's a remarkably big business when we think about it. And high school and club sports are also now very big businesses that we think about it. So it's hard to separate all of those. I don't know if that really answers the question, because it's a very difficult case by case situation.
Right.
And some things are result determinative.
Well, so let me ask one clarifying question, though, about financial aspects. When we talk about high school sports being big business, we are not talking about big business for the schools themselves, right? We're talking
No,
about who
they,
earns
they
money.
earn they earn comparatively little.
Right. So who
They
earns
spend
money
a lot more.
in high school athletics? Who earns the
In
money?
high school athletics, most of the earnings come from third party stakeholders. They're either going to be potentially coaches, facility operators, training centers. It's not as direct that they earn a lot of money in ticket sales or media rights. It's increasing, though, as we see it here, as we both are sitting in New Jersey today. New Jersey's high school federations have a broadcast contract for high school football, and all the schools in New Jersey are participating in that, sharing any revenue from it.
Okay.
But most places, high school sports operates either as a liability for opportunity for its students, or as at best a break-even proposition.
Got it. Okay, so that's super helpful. I think that gives a lot of important context to kind of what types of benefits we're kind of talking about. But if you were to characterize, who the primary beneficiaries are, or who are the primary beneficiaries are intended to be of high school sports versus college sports, who are the major stakeholders, and what benefits do they accrue?
In a perfect world, the community is the first beneficiary of a vibrant high school athletic program. That retention rates in school, graduation rates among athletes, behavioral issues, just community feeling tend to be heightened when there's a successful, vibrant, large scale participation in high school athletics. And we think about it. It's sort of, and it may be a historic and archaic model to some degree, but it's the idea that if kids are busy, if kids are engaged, they're going to be happier, they're going to be more successful, and less prone to some of the problems in the community. That can mean an awful lot, and we may take that to extremes now with having our kids engaged from a very, very early age at a myriad of things. But at least kind of the classic Victorian ideal that carries through almost all our sports today is that a broad pattern of sport engagement, opportunities for growth and health are all implicit in it. And to some degree, this was sort of the reason why Title IX was extended to the schools and is such an important aspect sociologically for in the United States, has been for a while, is that we've extended physical activity to women and as well to men. Phys ed classes have had a long and important lobby in the high school ranks. So the idea that this is a sign of a healthy community is sort of a maybe an archaic idea for us, but it's one that I think still really hangs on and has really important lobbies, particularly in today's society where we don't quite have those same measures of health.
So, in contrast, college sports certainly do, there's a certain amount of community alumni pride and connection to the school. But, what do you think is the primary driver of that motivates educational institutions to invest in and to, try and build successful athletics programs?
That's a great question. I'm going to answer by plotting a spectrum, which is probably going to our listeners will hate, but let's talk about them on one extreme. An old Division III athletic director, which was sort of a non-scholarship level of the NCAA that includes kind of prestigious liberal arts colleges and smaller universities, where athletic participation rates can be very, very high sometimes, but intensity is a little bit lower. Described it once at the Division III level, we run our athletic programs for the amusement of our students and the enjoyment of our athletes. At the Division I level, and he had experience in both, which is the highest level, we do it for the enjoyment and bravado of our alumni, and the professionalism that is attached to it, the money that is earned, and the attention that comes with it. I'll talk about another mentor who was an athletic director and one of the first female athletic directors of a major institution, Joan Cronin, who said that athletics is often the front porch of the university. It's the most public facing. It's the most emotionally connective aspect of it, and state pride can be on the line in any given day or week, sometimes in negative ways as we look at it. But if you think about what those indicia are, we can talk about those as positive in a couple of ways. Schools that are successful athletically, even from year to year, do much better in alumni donation and other donation because of those successful years. Athletic success has typically a positive correlation on applications to a college, which is a really important revenue stream. It also may have a very positive, by increasing the application pool, it also has a positive correlation to expanding the admissions pool to be better, more talented, and then raise rankings. And raised rankings become part of a virtuous cycle of athletics. The alumni give more, we win more, better students come, and we rise in the rankings. And I'll kind of go with a couple of historical precedents. In the 1990s, the University of Miami had a bit of a renaissance in college football. That came at some price. They were federally investigated for a Pell Grant scandal. They were placed on probation for NCAA violations. But the University of Miami's SAT median increased in their entering freshman class during that time period, increased by about 100 points, and they went up in the rankings broadly. You can trace this in a number of schools, and probably no school is a better beneficiary of this than maybe Duke University from its basketball tenure. I kind of correspond in age with this. I'm a guy who played football in the Ivy League and was really looking exclusively at Ivy schools when I was graduating from high school and where I would play. And to me, Duke was a nice school in North Carolina. In the course of my time graduating from college, they had a renaissance in basketball. Their SAT median had jumped by 200 points, and they were getting kids that would normally go to Harvard or Yale or Stanford. So everybody kind of wants to be in this happy kind of panaceic campus that athletics can create, and it does create a really much more attractive front porch in those circumstances. Now, what go on behind those scenes, we're seeing publicly every day, and I spent 5 years of my life trying to remedy it at a university that also had a great experience rising up academically and creating an identity for itself through athletics.
So there's a lot to gain for the institution in the success of college athletics in terms of reputation, financial benefits, recruiting. The overall health of the institution stands to benefit.
It certainly runs in the conventional wisdom, yeah, that and even two schools that really sort of dropped college athletics when they were participating at a more major level after scandals, NYU and the University of Chicago, high-level academic institutions, returned to athletics at various levels because they felt they needed to have that opportunity for participation. So I can't think of a major American university that doesn't consider athletics an important part of their identity.
Thank you. So let's pivot to talking about some of the recent cases that you alluded to that specifically have at their core state laws or state athletic conference policies regarding transgender athlete participation. So one that I want to talk about, the one I want to talk about first, partially because it's high profile and frequently discussed, but also because it's kind of we're on the brink of getting some sort of perhaps final decision from the court, is the Soule v. Connecticut Association of Schools case. So I'll give, I will link listeners to, information about the case and talk a little bit about it separately. But can you just talk a little bit about that case, what the legal issues were that were raised and ultimately addressed by the court, and kind of procedurally, like what has happened in that case?
Well, it's a very complex case, so let's go with it and try to get to at the easiest bottom. And you've certainly looked at it carefully too. So maybe in a conversational format. Initially, 3 young women, high school athletes, 2 seniors, 1 sophomore, were initially the plaintiffs in this case, alleging that 2 athletes who were born genetically male and had now assumed a female identity were hurting their opportunities to compete and win championships and titles, or at least because it sought injunctive relief, that it was an immediate irreparable harm if these 2 young people, in this case young women, but born as men, were allowed to compete in the upcoming season. So it sought an injunction.
Sorry, I just want to interject. And this is specifically in track and field.
It was one sport, and it was 2 people who posed the threat if they were allowed to compete.
Right.
And it challenged the Connecticut determination that a broad competition based on gender identity rather than birth sex.
Right. So the Connecticut Interscholastic Athletic Conference, which governs, which provides the kind of organizational structure and rules for all high school sports yep. in Connecticut who participate in the conference, had in effect for several years. I think
several years. It's 2014.
Yeah, 4 years at the time that this challenge was brought. A policy that allows students to participate according to their gender identity, right? And the sports team aligned with their gender identity.
And so it was a case seeking injunctive relief, saying that that if these young women, the plaintiffs, were or if the case of these two young women, if they were allowed to compete, it would cause an immediate and irreparable harm to the plaintiffs, the three women, and then later now a fourth woman who has been added to the suit because of the presence of these athletes.
And that was based on those two trans girls' prior performance. So the athletes, one of them, I think, has been very public in discussing the case and her experience. Andrea Yearwood, but also Terry Harris is the second girl whose participation was challenged.
Right. And it obviously, track and field, there is the element of time attached to it, or distance in the right context. So there is some predictability if you compare best times and lifetime bests, that these women might be not able to win titles, not able to compete. This is, however, it's something that's really unusual in sport, because in almost any sport case, you never look to disqualify participants on the eve of competition and then reorder them, or have looked at a harm if a certain competitor is allowed to compete. It is a modern kind of interesting idea. What's also interesting and novel in this case is that the plaintiffs were also looking to the anti-discrimination statute, Title IX, to provide them with their basis for their lawsuit. That Title IX would prevent, or it should prevent, injury to women that would be disruptive of their educational experience on the basis of sex. Well, in this case, that they're alleging that the participation of the transgender women would do that to the women who were cisgendered.
Yeah.
It is a remarkably convoluted set of facts, and one that, at least in this circumstance, is fairly novel.
So, right. So I actually have some quotes from the case, from the complaint, which is, again, and it is novel because they're taking the position of the plaintiffs in this case was that this was a straight, I shouldn't use that word, that this was a clear-cut case of purely just gender discrimination, because and at the core of their argument is their assertion that trans girls are really boys competing on girls' teams, right? And so because of this, the language of the complaint is that more boys than girls are experiencing victory and gaining the advantages that follow, even though postseason competition is nominally designed to ensure that equal numbers of boys and girls advance to higher levels of competition. So because Andrea and Terry just both happen to be exceptional athletes in their sport, they placed well in a few events, right? More than one event. And then the argument is they precluded some cisgender girls from, running in sort of postseason competition.
Right, and flip the gender balance of gender equality guaranteed under Title IX. That's the novel part of the argument. We've never seen that brought before. We've seen Title IX defined in participatory opportunity. We've seen it defined in facility fairness. We've seen it defined in a lot of different ways. We've never seen something like this, the right to win and the wrong people taking up space in those participatory opportunities. And I think one of the harms that the cisgendered women as plaintiffs argued was that their placings, their ranks, their chance for advancement, their chance for college scholarships, and the joys of victory would be diminished. And again, that's a real reach in individual sports. Given it, all you have to do is go out to any road race in any town and find people winning winning their age group, running personal bests, and not finishing first. And the participation is still strong. So it was a unique and novel argument, particularly to use the principles of Title IX, which in its history is exclusively an anti-discrimination law made to create opportunities for women, not to define who the women are who seek them.
And so just from like a procedural standpoint, then so in seeking injunctive relief, they sought not just to keep Andrea and Terry from running in the 2018 championship, but they also wanted to change existing records to remove Terry and Andrea's times and to move up athletes who finished after them.
And essentially, they wanted a cleansing of the record.
Right.
Again, something that has happened in sport in the case of disqualification, but not something we've seen broadly in the idea that history would be widely rewritten like that.
So let's talk about what the district court in Connecticut, what the district court decided.
The district court did not granted summary judgment to the defendants in this case, saying that there was no issue of fact or law over which reasonable minds could differ in the interpretation of the policy, and declined to go to really cognize any of the claims brought by the plaintiffs, particularly as defined the rule. In this case, that the rule was on its face neutral.
Yeah, and I think it's for non-lawyers, if you read this opinion, you'd probably be very confused and bored by the first part, which is a very long discussion of mootness and standing. And
we don't want people's eyes to glaze over or drift off to sleep if they're driving in cars. And that really was it. Just in the general principle of all American cases, you have to bring a conflict by which the court can provide some relief. And then the other question is, if you're bringing that, are you the right person to bring that? Is there relief you can be granted? And I think the court looked at this and said that was really remote for these young women to have the record book rewritten, to have the people above them in a standing expunged, or to looking forward, have those people who might be otherwise eligible removed under these standards. And it certainly does smack to the participation of the two transgender women or girls in this case, at least using the high school terminology, because their right to compete would have been at stake and infringed, and they would have been plaintiffs in a separate action. So the court really does take up this issue of mootness and justiciability. And because COVID happened in the middle of this case wasn't really heard immediately. It took a delay, and obviously there were no high school sports for some of this time, allowing at least some of the plaintiffs to graduate.
Yeah, and the championship in question never happened, right? Like that meet never took place, right? So yeah, there's obviously an issue of mootness. But this question of, whether the injunctive relief was properly denied, right? Whether the motion to dismiss was proper for failure to state a claim was appealed, right, to the Second Circuit Court of Appeals. And then the issues then that needed to be addressed on appeal were, whether there was in fact an injury in fact, right, whether there was a actual injury suffered by the plaintiffs, or at least one of the plaintiffs, right? It didn't have to be all of them. And whether that was actually redressable through the injunctive relief, which is preventing them from running and changing the records, whether those remedies could actually fix the harm that the plaintiffs theoretically suffered. There was a separate issue too, which is whether Title IX even allows this type of private cause of action to be brought, right? Which it typically does not. So can you talk a little bit about that as well?
Yeah, Title IX actions generally don't allow money damages to flow out of them. In other words, I could sue my school district because I'm not receiving enough opportunities as a female athlete, but it's generally not that I'm going to get any kind of monetary benefit attached to this lawsuit. And this lawsuit did have a claim for money damages attached, which is again unusual unless it would be a case of unequal facility where you would be looking at that women had been disadvantaged to a certain number in dollar figure terms. But yeah, and the case turned on the issue there. Did the school district have notice, or the school district association have notice that money damages would be a part of this? And the court determined in that case, no, they didn't have such notice, that there wasn't a basis to assume that they would understand that they would be liable for money damages to these athletes. I also would think that it also flows out of that, as it's very difficult, back to our prior conversation, to connect a dollar value to the idea that someone comes in second in an event versus someone coming in first. Uh, in almost any circumstance, we struggle with that, and it's wildly speculative, particularly in high school sports. The idea that if I play second or third or fourth in the state meet and I'm on the podium and the winner would be subsequently disqualified, can we assess some harm or damage in that placement difference? If I lost the opportunity to compete, maybe there's an issue, but I don't know if money damages are there, and that's where the court couldn't infer that. It was very, very speculative, and it's very difficult to calculate what that loss would be. We're seeing a couple of different analogous situations. We're trying now, in the era of NIL, that if a player is cut from a team or if a player doesn't receive their college opportunities appropriately, we try to assess the damage of it. But again, in the high school sports ranks, it's very difficult to put dollar figures on those concepts,
Right.
or differentiate a lifetime earning.
Exactly. And I think, and that is like a big part of the Second Circuit's, the majority opinion, is that it is so speculative, even if the plaintiffs claim that, they were deprived of the opportunity to be champions and that being champions might have an impact on their future job prospects. The court was kind of not dismissive, but just skeptical of the idea that somehow placing first versus second or seventh versus eighth in a high school track championship would have an impact on their employability, that's so speculative. And they really didn't offer any evidence to support that assertion, right? It really was just mere speculation. They didn't have like an employer who said, for example, oh, well, I would have offered this athlete a job as a coach, but they placed second instead of first, or eighth instead of ninth, and therefore I did not, or seventh and eighth instead of seventh, so I didn't offer them the job, right? So there was no evidence that there was any actual harm.
And we've seen this sort of throughout the history of sport, and there are widespread apocryphal tales, maybe not exactly factual ones, that athletes were offered scholarships contingent upon winning a state title or placing in a certain spot. That's possible. I don't argue that those opportunities wouldn't exist, but it certainly becomes an issue. I think it's actually, and maybe if you were thinking about the real value of this, it's probably in college essay terms. terms, if we were to think about it, how you would distinguish yourself, how you would refer to yourself. In a lot of NCAA sports, if you finish in the top 8, you get all American honors. It goes with it. Um, it's interesting. Could you refer to your 4-year college track or college swimming career as a 4-year career? But if you finished ninth and you never got All American honors, you wouldn't be an All American, so maybe you wouldn't be hired. I guess. I know a lot of people who are, and this may be a digression, so I want to be careful. I know a lot of people who are Olympians who now use the abbreviation OLY after their name to signify they were Olympians. None of them were Olympic champions who are using that. But if you're an Olympic champion or you're an Olympian, I think you're in pretty elite company. So maybe there are some possibilities that there are outside acknowledgments that would forever mark you, but it's really hard to put any kind of economic value on them other than maybe in the admission to a particularly selective college or in the idea that there might be a slightly larger scholarship dollar or a slightly more interesting graduate school admissions essay out of this. It's very narrow.
Right. And, like what the Second Circuit specifically says is that, changing the records would not, in the quotas, would not bind any prospective employers who consider hiring plaintiffs because they are not before the court, and thus a favorable decision for the plaintiffs is not likely to change their future employment prospects or outcomes.
That's right. I'd like to forevermore be known as a Heisman Trophy winner, but I'm not.
So I think another piece of this that is worth discussing, even though the court did not address it at any point, is that, a big part of the plaintiff's argument is that it was so fundamentally unfair that the deck was so stacked against the cisgender girls competing against these transgender girls. But when you actually pull up the records and look, these plaintiffs were putting out times that were within tenths of a second, in many cases, of the transgender girls whose performance was at issue, and in multiple instances, the transgender athletes were beat by cisgender girls in events. So it's a bit of a stretch if you're offering up these statistics that and a big part of the argument made is that, well, biological males have a 10 to 20% athletic performance advantage over females, and thus this is so fundamentally unfair, and that the deck is just so stacked against the cisgender girls. But none of that was even borne out by the facts. And I think there's also, and again, this is just conjecture on my part, I am not a fast runner at all, or a competitive athlete, but I think there's something to be said too for performance being to some degree the product of environment, right? So who's to say that if you as a cisgender girl were not running against these transgender girls, that you would have even gotten the time that you got, right? That
you run faster as a result of your competition. Right. Sarah, I think you're hitting at one of the and this is more sport philosophy than legal philosophy. You're kind of hitting at the reason why we have competitive categories in sport. And if we did them not based on gender, we do them on objective factors like time or proficiency. And so one of the reasons why we seek fairness in our categories is the idea so that there can be a level competitive playing field. And I think it's very difficult when you see performance being competitive and not dominant to begin to infer that these people, the transgender girls in this case, were at such distinct advantage, or the cisgender women in this case were at such distinct advantage for the trans girls, and that the cisgender girls are at such distinct disadvantage. They are kind of a shuffled deck of competitiveness, which sort of suggests to me, from the outside looking in, that they're in the right category, um, and that these young trans girls would not be competitive with boys now at their age group level, who would be running faster times, and that the argument in this case for identity seems to be fair.
So this case is interesting also to me because of who the plaintiffs were represented by. So, in other conversations that I've had, I've talked about sort of the like just practical challenges of bringing a, private cause of action under Title IX. That first there are administrative processes that one needs to go through. That you need to file a complaint. There needs to be an investigation by the Office of Civil Rights, and there's all of these things that need to happen before you even get to your ability to file a private claim, and that there's a lot of money and time involved in that. And one might say, like, what motivated the parents of these high school girls to engage in this litigation and keep it going even long after their kids had graduated from high school and moved on to college, where they are all running track incidentally. And so, the plaintiffs in this case were represented by counsel from the Alliance Defending Freedom. I will go into greater detail about the Alliance Defending Freedom, but for the purposes of this conversation, let's just say that the Alliance Defending Freedom is a Christian legal organization that involves itself in legal issues and disputes that are aligned with a very specific religious and also political agenda.
Conservative or fundamentalist legal issues, right? They would probably say that they were the conservative ACLU, but the power of the ACLU in some measure is that they're neither liberal or conservative. They're rights oriented and for expanded civil rights in most cases. This group is clearly cause oriented, and that's one of the reasons why they've ended up on a list of hate groups by the Southern Poverty Law Center, and they're focused on this. And I think this is important kind of to think about, that the three women who ultimately became plaintiffs now and then added a fourth were really being sought out as class representatives more than maybe their own organic perception drove them to this. They were picked and selected, as far as I know, to maintain a lawsuit. And a lot of times, it's not unusual in class action lawsuits. We always look for a representative who's willing to put their name on the suit and be represented. That they were willing to do this certainly says something about them, but it also says something about why this group was doing this and why they were doing it in Connecticut, which was unique. I think the short answer why they were doing it in Connecticut is that Connecticut's association had adopted a fairly progressive policy on gender identity, and was enforcing it several years earlier. And I think the second reason is maybe a more practical one legally. If they could get a win in the courts in the Second Circuit, that would probably set the tone across the country. The Second Circuit's one of the more liberal circuits in the country, and I think they thought this would help propel their argument forward, or they would find a series of reasoning that would allow them to argue a split in circuits down the road and get to the Supreme Court with jurisdiction. So it was, from a legal standpoint, this was very much a test case, and it was one to take on an association that didn't have purely state standing.
And I should mention this, even though the Second Circuit upheld the district court's decision, now the Second Circuit has agreed to rehear the appeal en banc, which it just is a fancy legal way of saying an entire panel of Second Circuit judges rather than just the three.
Right. Right.
Um,
I mean, it typically you get a three judge panel in an appeal in a federal case. The standard is fairly narrow to what they can review the case on, and then the idea of you don't like the outcome there, or it isn't decided on the full sense of facts that you're trying to make. You can ask for an en banc decision, meaning all the judges sitting named on the circuit would sit on this decision. It's a very rare thing. In fact, the last sports case I could think of that got to an en banc decision was the case of Tom Brady and the Deflategate case. But it's very rare, and it's granted in less than 10% of the cases that go in that circuit, and the outcome is determined or changed in less than 2% of those cases. What the alliance has come forward with, the plaintiffs' lawyers, they've asked for consideration of some new issues, or not new issues, but issues that weren't determinative in the appeals court decision.
But when you look at what the parties were asked to brief en banc, it doesn't really seem that any more substantive, or I think more socially consequential issues will even be addressed. I mean, it's really kind of just, again, rehashing whether there's an injury in fact, whether that injury in fact is redressable, and whether the plaintiffs can in fact
Get
seek
money
damages
Yeah.
under Title IX. So
Yeah, and that's exactly right. It's not a really radical change, and it is maybe it is a factually distinctive one as to a couple of the different plaintiffs and their injury, maybe the only issue. But as you said, I think again for the alliance, it's keeping this case alive and in the news is providing them the ultimate gain. Particularly, I think it's provided an uproar in states that are more conservative leaning that this is an important social issue. Um, at least in sport, it's affecting a very small number of athletes. We're talking about 2 in Connecticut. We're talking about small numbers across the United States of athletes who might be affected by this. Yet it's such a prominent issue in the political agenda and talk of the day.
yeah, and I also see it as an opportunity for the ADF, the Alliance Defending Freedom, to continue to kind of put out into the court record a rhetoric about transgender people in general, right? Like through the misgendering of the athletes involved, continuously referring to them as males, boys, etc., and making this sort of essentialist biological argument about the athletic supremacy or the physical supremacy of biological males over biological females that serves a broader agenda. And it's not even really about these female athletes.
Well, it has very little to do with them, unfortunately. You are getting that rhetoric in this chain of cases, and then this kind of horrified reaction to it that it's gutting Title IX, it's destroying women's sports. That practically can't be further from the truth. At least in the place that I look at more carefully, in collegiate sports, women's sports enjoyed one of their most successful seasons back after COVID. Women's basketball that had sort of not increased viewership and not had compelling matchups had one of its most compelling matchups. If we look at name, image, and likeness earnings for female athletes, at least one female athlete may be the highest earner in all of college athletics in terms of NIL, and she's a women's gymnast from LSU who will work very hard at it, as opposed to using a high level of status to take advantage of those opportunities, earning we estimate about $3 to $5 million per year in the first year or so of NIL, including the opportunities to put women on TV in different ways. So if we look at the marketplace reaction to these cases and a death of women's sports, we're seeing just the opposite in the marketplace.
Well, and so I think the reason why I wanted to, and I will again talk about these cases more separately from our conversation, but the ADF also is involved or was involved in two other cases about transgender athletic participation, but these were cases challenging state laws that restricted inclusion of transgender athletes. So one, Hecox v. Little, was challenging Idaho's state law, and then the ACLU v. West Virginia case, where again West Virginia's athletic participation law was challenged. The ADF intervened in both cases, representing a cisgender female athlete to essentially support the position of the state in defending their law in both cases. And so in the Hecox case, I mean, that ultimately, there was a preliminary injunction granted to the plaintiff, who was a trans athlete in that case, which kept the law from going into effect. That was appealed to the Ninth Circuit, and the Ninth Circuit actually upheld the district court's decision. So can you talk a little bit about the basis for that decision?
Yeah, the Hecox case very quickly is that the elite athletic regulatory bodies like the NCAA, the IOC, actually do allow transgender women to compete subject to certain criteria. Uh, the act, the Idaho state law, basically said no. It was an absolute bar. It affected the plaintiff, Ms. Hecox, who who was transgender from quite some time ago, and a college student in Idaho, from participating at all, simply with the hard bar based on birth sex rather than any other characteristic. And this is one of the intrinsic areas that I'm sure you've talked about, and we'll talk about throughout the series, is that this is maybe not the perfect way of defining athletic competition, particularly in the athletic sense, or defining identity, maybe. And so the court and the Ninth Circuit basically held that this was an absolute bar, that it was too strong, and it provided an immediate irreparable harm to Ms. Hecox in this circumstance, with no real burden on anyone else. So the state law was overbroad. One of my favorite areas of law is the idea of injunctive relief. And anybody who's a sports lawyer, sports law cases almost always have a claim for injunctive relief because, and these cases illustrate it very well, the timing is the issue. You really care about what's happening next now for the next competition. You're not so much worried about waiting for a formal hearing on the merits. So this was, again, a case on injunctive relief. And in this case, the court was affirmative in upholding an injunction, saying that the burden, that the immediate irreparable harm that Ms. Hecox would suffer in the process far outweighed any objections that the state or any interest the state had in protecting any of these interests. So the balance of the equities absolutely favored her. And if you read the case and look at the case decision, it is becoming a forum for sort of a who's who in law to be interveners and issue friends of the court briefs. The association of largely basically every Democratic attorney general in the country entered this. There were multiple interest groups, solicitor generals across the country, and large law firms on behalf of various groups, including industry groups, filed amicus curiae briefs in this case. Many on the side of the plaintiff. This case, the transgender young woman who was suing and to get the injunction and against an overbroad law. Again, this is a bizarre forum, at least, and this is beyond, to some degree, my pay grade as a sports lawyer. But sport has become a bizarre forum by which we fight over definitions of gender and definitions of eligibility, particularly with no clear harm showing up.
Well, and I think what's particularly significant to me about the Ninth Circuit's opinion in this case is, they really they were very clear about their reasoning that heightened scrutiny should apply to laws where discrimination is based on transgender status. And that's consistent with what courts have held in other contexts, right? That
Yep.
transgender status is not the same as, but should be treated the same as discrimination on the basis of sex.
And flips the argument back to the plaintiff in this case being discriminated on the basis of sex, but her sexual identity having to go through this. And Idaho had put in this really draconian sexual verification process that would
Right.
making anyone go through it would certainly have certain pause.
Right. And under the law, anyone identifying as a female would have to go through it. And so it
Right.
affects actually like a pretty broad group of people.
So Idaho came up with the most draconian way of doing this as opposed to the least.
So now the West Virginia case, though, at least at this point, is kind of going the other way. So the state law.
Opposite result, state law upheld, injunction failed.
Right. And it is pending appeal to the Fourth Circuit. So I think it's important to talk about the fact that for a non-legal observer, it is tempting to look at these as like victories or losses on whichever side. But I think arguably for the Alliance Defending Freedom, these battles are important, but not their specific and individual outcomes, that they're part of a broader campaign. And I want to kind of highlight that. And again, we're just speculating here because we are not ADF members and we have no idea what their litigation strategy is or what their organizational priorities are, but they are pretty clear about like what their agenda is, right? Which is to prevent trans women and girls from competing on sports teams with cisgender women and girls, right? So, what do you see as sort of the end game here?
I think for the alliance, and obviously, again, wildly speculating, it is to call attention to this issue. It is to motivate people to follow or who follow that, to draw them closer and to make this battle a public one. This is an important forum for them, even though it's a very small forum. I think of it as a very small issue in sport. I'll give you this may be again a slight digression, but I think there's a very similar issue back in the 1990s. A golfer by the name of Casey Martin, who had a congenital leg issue, but was a collegiate champion, sued the PGA to get on the golf tour, which he had qualified for, and then asked for an accommodation under the Americans with Disabilities Act. The Golf Association, then as now, rather than embracing Martin and saying, "Aren't you a nice young man? And isn't it great that you're doing this? And wouldn't this expand the people who played golf?" immediately attacked him and said, "No, it would destroy golf as we know it." The Supreme Court, ultimately on a 7-2 decision, ruled that the issue of a cart or carrying your own bags, and Martin's chief claim was that he couldn't carry his bags, was really immaterial to golf. It wasn't a time game. It wasn't an endurance competition. Professional golfers smoked while playing. Golfers on the weekend drink while playing. It wasn't part of the sport. But it was such a small case, and the reaction of golf was so extreme that it became such a social issue. And I think it helped to a degree fundamentally create acceptance for the Americans with Disabilities Act, an important idea. Ultimately, Casey Martin went on the tour, won no tournaments, and was universally attacked for this. To some degree, I think this is a parallel for what the alliance in this case is doing. they're trying to create the maximum attention, the maximum fear, and the maximum sense that the institutions they hold dear, that we all hold dear, the most important of those being gender, is under a great assault in sports, which it isn't. And the plaintiffs, who are people who might place a couple of places higher, but for certain participation, are the ones who are being hurt and stepping into this. So we need to protect them, i.e., we're protecting women. The fact that they're using an anti-discrimination statute, Title IX, to do that, I find particularly interesting and maybe a little bit tragic.
So I think for me, what I foresee coming is there will be, a split between the circuits on how they find.
Certainly, the West Virginia case points to that, right? We're heading toward the Fourth Circuit having a different opinion. We're suspecting the Ninth and Second will have different opinions, and that will get to a more conservative Supreme Court, right?
Possibly, right. And it does turn, though, on, ultimately what the issues are that the circuit court is deciding, and all of these things. There has to truly be a split on the issues, which it's unclear yet, because, right, the Fourth Circuit hasn't even granted appeal, I don't think, on the West Virginia case. What issues they will agree to hear on appeal. But should there be a split on the issues, right, then the possibility that the currently conservative Supreme Court will hear one of these cases is significantly increased, right? And so then this becomes a national issue, and possibly an issue of, lasting significance, and implications beyond just the sports arena, implications that would affect transgender people's civil rights in perhaps multiple forums.
It certainly can. And again, when you think about it in athletics, particularly because there's always a competition coming up that will affect someone in a very short or finite career, there's always somebody suffering an irreparable harm. So even if it limited opportunities in athletics for athletic participation for a short time, it could have a profound effect.
Yeah, absolutely. And I also, though, think that because a lot of these state laws are geared towards restricting access in educational settings, that it can have implications on transgender youth being accommodated and being respected in their educational environments beyond just participation in sports.
No, I think that's very much the reality. And if you're not from that particular camp or segment of belief, you kind of live largely unaware of this being a major issue or a fraught issue. I probably am someone who sees it only because I see cases of conflict. I don't really get up in the morning and worry about someone winning a title because their birth gender is different than their current identity. I think it's really remarkable in the sports context that maybe still the most remarkable case on gender is that in North Carolina, their proposition that prohibited people using a restroom that was different than their birth gender suddenly became a reason they lost the thing they love best in a lot of ways, college basketball, for several years, with the NCAA taking college basketball away until a new governor and a new legislature could repeal this law. But it's remarkable how dug in certain populations are on these issues and what they're willing to remove. So I think that, as you say, this could be a slippery slope that we would come down in a variety of circumstances. But athletics, because of its public nature, athletics because people care about it and it engenders emotion, is a great test area for these.
Yeah, and it is still a very gendered space, and it's a space where there is sort of an implicit acceptance that gender matters more than in other types of spaces like employment or housing or, other aspects of our lives, right? That the idea that we can somehow not see gender in sport is, even for the most open-minded of us, it does seem somewhat like absurd, right? Um, and I think that, sports are one of the last few areas of our lives where separation by gender is presumptively like okay. Like we
It,
are okay with that.
it is
So
one of the places where that's how we divide, right? In a natural setting, even on the basis of competitiveness, right? It's not necessarily on
right,
the base. We don't use gender particularly as defining, other than defining the competition as fair.
right. Well, and I'm going to explore, I will explore that question of like whether there is any basis to that, like any real scientific basis to that more. But I think that again, it's a it's a narrow forum, but it could have potentially much larger implications. And I really appreciate your insights.
We're moving. I've shocked my students over the years by saying we're moving into an area where gender may be less important athletically than it ever has been. If we trace the times that women in the marathon are decreasing, they'll intersect with men within the next decade. Um, if we look at some other sports where women may be better qualified to produce at the highest level than men because of calmness and heart rate and other issues like that, these may be really interesting times in that way. And obviously, if your definitions of traditionalism make that very difficult to take, sports has always been an avenue or an arena for greater inclusion and greater understanding because we see performance as the key. So it is an interesting time in that way, and I think you'll see more sports cases talk about this subject in particular.
Thank you, Bob. I really appreciate your thoughtful conversation on this topic. So